All right. Good evening, everyone. I'm Reverend Mary Pfeiffer. Thank you for joining um, the Police Reform Advisory Committee's meeting for March. Our scope of work includes to further evaluate suggested and tabled recommendations outlined in the Police Reform and Reinvention Collaborative plan that was adopted by our Board of Trustees in 2021. So, as outlined in our annual Board of Trustees update last year, we are reviewing recommendation number 14, which states that the village should support efforts at the county and state levels to reform indemnification of officers and to eliminate qualified immunity as a defense in civil suits against an OPD defendant. So, um, our topic tonight is the impact of qualified immunity. And so we welcome our panelists who will be introduced by our moderator. But in the meantime, I'd like to thank again Mayor Rika Levin for coming and Trustee Dana White, Chief Zimmerman, and from our PRAC team, we have Bishop Whitaker, Althema Goodson, Jennifer Twill, who is town council member, Sergeant Pat McGovern, Jennifer Cabrera, Kimmy Pogue. Sorry, I'm going through the names. Okay, and then from our police, I'm sorry, our newest member of PRAC is Polly Puner. So she is here as well. So our whole team is here. Thank you, PRAC. And Jennifer Carrera is also part of the CPCRB, which is the Civilian Police Complaint Review Board. And we also have from that board the chair, I'm sorry, Michael Aurora, and I saw Kimberly Cohen. Trying to find all the folks. My apologies if I'm not. Oh, there he is. And Ernest Addo from the CPCRB. And thank you also, Captain Donahue, for being here. And I don't see, is that Officer Chavez? I'm sorry, I don't know all of the names, but thank you all from all of your particular points from Ossining, joining in on this important conversation that we're having tonight. So our teams, PRAC and CPCRB, will engage the panel with questions at the end of the presentation. So the public is invited to listen into our meetings. And again, thank you all for being here tonight. And I will turn things over to our moderator, Jermaine Smith, who is a part of our PRAC. My apologies if I didn't say your name earlier.
Oh, no, no problem. Good evening, everyone. Thank you for joining. Could you mute? Could everyone please mute while we're just going through this? Again, good evening, everyone. Thank you for joining. Have the honor of introducing our panelists today, and then I'll try to just keep the conversation flowing, allow our panelists to do a little bit of explanation of qualified immunity, and then some of the benefits and some of the pros and cons of doing that, and then we'll get into some questions and allow them to answer some questions from PRAC as well as the CPCRB. So I'll get into the introductions, and then we can get going a little bit. First, we have Dr. Tyron Pope. He teaches Introduction to Criminal Justice Sociology and Africana Studies, as well as courses that explore research methodology in criminology and sociology at Iona University and at the City University of New York, John Jay College for Criminal Justice. He's a retired NYPD officer where he served as Sergeant Supervisor Detective Squad for the Organized Crime Control Bureau, Narcotics Division from 1992 to 2012. In his 20 years in his 20 years of service, he has worked in various capacities, including major crime narcotics operations, street level buy and bust enforcement, homicide, counterintelligence, and internal investigations. Dr. Pope has received a doctorate in education, which focus on social justice issues from an executive leadership program of St. John's Fisher University. His dissertation was entitled The Reimagination of School Safety Concept and Phenomenological Narrative Study of School Leaders' Perspective of School Safety Pertaining to the Effects of the Removal of School Safety Personnel from Public Schools. It examined the calls for defunding police, the removal of school safety personnel from educational institutions, and school leadership shared decision making during crisis planning, restorative justice, and disciplinary issues dealing with school safety and gun violence. Dr. Pope also is also the owner of Principal Management and principal manager of Truth to Power Consultant LLC, an investigation consulting firm providing educational leadership and management, school safety services, security assessment, private investigation, and intelligence services, as well as and intellectual property rights protection, litigation support, expert testimony, security consulting, and risk management. He's going to give us a little bit of an introduction into the overview of qualified immunity. Our second panelist, Captain Jeffrey Wise, Captain S. Wise is the commanding officer of the Westchester County Department of Public Safety, Professional Standards and Training Bureau, overseeing the Department of Internal Affairs functions and the Westchester County Police Department Academy. Captain Wise has been an officer since 1999, first as a patrol officer and with the NYPD for 5 years, and then with the Department of Public Safety, where he has served in various operational and administrative positions, including coordinating of the 2008 Westchester County Panel for Review of Use of Force. Captain Wise earned a Bachelor of Arts degree in law. Sorry, my text is a little messed up here. And law and sociology from SUNY Binghamton in 1988, and as Juris Doctorate from Boston College in 1991. Our last panelist is Katarina Sira. I hope I'm pronouncing that right, Katarina. Okay, thank you. Co-leader of the campaign to End Qualified Immunity in New York, spearheading a grassroots effort to enhance accountability and justice for victims of official misconduct. As Deputy Director of NYU's Peace Research and Educational Program, she partners with governments, universities, and community organizations across Colombia, Liberia, Iraq, Moldova, and Sierra Leone to advance peace and reconciliation initiatives. Her background includes leadership roles with the UNHCR and the U.S. Refugee admissions program in Africa, where she's the director of resettlement missions and child protection programs. Katarina holds a BA from Skidmore College and an MS from NYU Center for Global Affairs, where she now serves as an adjunct professor. So again, thank you panelists for joining. I hope I did you some justice in trying to go through that, your guys' introduction. What I would like to do to get started is before we allow you guys to share, and then I would like Dr. Pope to be the first to speak and give us a overview of qualified immunity. So I would like you guys to just first share a little bit if you have anything you want to say before we really dig in, and then we'll get into that overview of qualified immunity. So I'll let Katarina go first, and then we'll go to Captain Wise, and then we'll end with you, Dr. Pope, and then we'll allow you to get going.
Well, thank you for the introduction. You did do me justice, so thanks, Jermaine. And thank you to everyone for being here tonight. I think it's amazing. You know, I've done a lot of sharing and talking about qualified immunity, but it's rare to have so many people who actually have power over these decisions and who are directly impacted. And so thank you for being here, and I'm looking forward to this conversation.
Thank you. Captain Wise?
Likewise, I'm happy to be here to participate in the conversation, and I look forward to addressing issues and answering questions.
Thank you so much. And then Dr. Pope, the same, if you want to open up, and then you can jump right into sharing us with a overview of what qualified immunity actually is.
Hey, good evening. First, I'd like to thank the Ossining Police Reform and Advisory Committee for inviting me to speak for this time topic. Again, my name is Dr. Tyrone Pope, and I don't want to go too in depth because Mr. Smith just said the whole So I'm happy to be here with Captain Weiss, and Katerina Sierra. So what we're going to do is tonight is we're going to explore something that is often controversial, and we call that qualified immunity. So would you like me to begin?
Yeah, if you can begin, give us an overview of what qualified immunity actually is.
Okay, so tonight, what we will do, we're going to provide a comprehensive overview of qualified immunity, examining its definition, the historical context, the pros and cons, key legal cases, and its impact on both law enforcement and communities. Particularly when we look at this, we look at marginalized communities and we look at communities of color. Okay, so my goal tonight is to lay a solid foundation for this discussion, to offer a balanced and informed perspective on this critical issue. So let's start off with the definition of qualified immunity. So qualified immunity is a doctrine that protects government officials, including police officers, from civil liability from discretionary actions performed within their official capacity, okay? Unless they violated clearly established law. And what this means, okay? This means that even if a government official violates someone's constitutional rights, they are immune from lawsuits unless a previous court decision has found nearly an identical conduct to be illegal. All right. The doctrine was established by the United States Supreme Court in 1967 in the landmark case of Pearson versus v. Roy, which involved civil rights activists who were wrongfully arrested under an unconstitutional law. The court then ruled that police officers could not be held liable if they acted in good faith and did not violate clearly established rights. So let's get into the historical context and expand on this. So over the decades, the scope of qualified immunity has expanded significantly, all right, through various jurisdictions and various judicial interpretations. The 1982 case of Harlow v. Fitzgerald, the Supreme Court shifted the standard from subjective good faith to an objective standard, focusing on whether the right in question was established at the time of the alleged misconduct. This change, all right, made it increasingly difficult for plaintiffs to overcome the qualified immunity defense. For example, all right, in the case of Kaesler v. Hughes in 2018, the Supreme Court granted qualified immunity to an officer who shot a woman holding a knife, despite being several feet away from her and anyone else. All right, because there was no previous case with sufficient similarity, the circumstances were, looked at differently. All right, let's get into the pros and cons of qualified immunity. Let's just look at the pros. All right.
Before you get into the pros and cons from your perspective, also want to give Captain Weiss an opportunity to share a piece. So I want Captain Weiss, if you can get in and talk about the benefits of qualified immunity from the police office perspective, and then we have Katerina do benefits of community ending qualified immunity. If we can talk a little bit about that, and then we get into a little bit more.
Well, sure. Actually, what I was actually prepared to do was I have a presentation that's going to take about 12 odd minutes or so. I don't know if we're just going to go back and forth, because I'll wing that if need be. But just so I'm up front, that wasn't the format I was anticipating.
Okay.
Yeah, same here. I basically, broke down a basic overview, and with Katerina and Captain Weiss to go more in depth. So, I was going to touch on these 7 simple points but briefly, and they will go more in depth into the actual pros and cons.
Okay, so let's do this, Dr. Pope. So finish your points, and then we let Captain Weiss go through his presentation, and then we'll get Katarina to go.
Okay, you know where I go. I'll leave the pros and cons
Okay.
to Captain Weiss and Katarina, and what I will go into is the actual impact from law enforcement and the communities it affect, and I'll look at New York State and qualified immunity and sum it up all in one. Okay.
Okay, fantastic. Thank you.
Right. So let's go into the impact on law enforcement, all right, and communities. Qualified immunity affects law enforcement and communities differently. Politically, policymakers are divided, all right, with some advocating for reform itself to restore trust, while others are maintaining protections to preserve police effectiveness. Economically, police departments could face higher costs if officers are more frequently subject to these types of civil lawsuits. All right. Socioeconomically, we look at reform efforts, including those addressing qualified immunity. When we look at disproportionate effects, how it affects low-income communities and particularly communities of color. So, who are more likely to experience negative police actions? All right. The legal barriers that are posed to this by qualified immunity can prevent these communities from achieving justice when civil rights violations occur and are perpetuated through systemic inequalities. Okay. So we look at New York State and qualified immunity. And New York State is key because this is where we're at. New York City made a landmark move. All right. In March 2021, largely by eliminating qualified immunity for police officers, allowing individuals to sue for constitutional rights violations. Right. This legislation was part of a broader police accountability package and signaled a shift in how the doctrine is viewed. But however, the state level qualified immunity remains in effect with legislative proposals that abolish its meeting its resistance. All right. So this opposition primarily comes from law enforcement unions and some lawmakers who argue that removing the doctrine could expose officers to frivolous lawsuits and hinder their ability to perform their duties effectively. But meanwhile, we look at reform advocates and they argue that New York City's experience could serve as a test case for this broader statewide reforms and potentially influencing future legal efforts. Okay. So all in all, by addressing these issues and looking at qualified immunity from an outside lens, it requires a nuanced approach. You know, we have to go about it with an open mind because we have to balance police protection, but we have to hold the police accountable. Okay. And while reforming or abolishing qualified immunity, this can enhance the quality of justice, particularly in communities that we serve, and essentially consider broader implications of law enforcement and public safety. So that's the basic overview of qualified immunity, and I leave it to Mr. Smith.
All right, thank you so much. Appreciate that. And Captain Wise, if you can get into your presentation, you said it's about 12 minutes or so.
Yep, depending on how quickly I speak. So I got to balance, intelligibility from time, but I'll do my best here. So
no, you're fine.
So first of all, as you all know, I've been asked to speak this evening to the benefits of qualified immunity to police officers. I'm going to be followed by a presentation explaining the benefits to the community of ending qualified immunity. I'm sure that no omission was intended, but let me suggest that the framing of this issue suggests a zero-sum paradigm. That is to say that qualified immunity benefits the police only to the detriment of the community. I posit that that's not the case, and that qualified immunity does have some benefit to the community as well. Recall what qualified immunity requires. It requires that the right to be free from particular police conduct must be clearly established before a police officer will be held to account for violating the right. So police officers, of course, benefit from qualified immunity in that they will not be held to account for actions that they had no reason to believe would be found to violate someone's civil rights. Now, from this, the community benefits when police don't have to conduct their duties in fear that they will be required to engage in protracted litigation and be held liable for actions that they could not reasonably be expected to know are improper. As much as the community doesn't benefit from overly zealous policing, it also doesn't benefit from overly timid policing. In addition, and more tangibly, hold harmless laws in New York and elsewhere provide that municipalities will pay the cost of defense and any judgment for compensatory damages in connection with claims against police officers who act in the performance of their duties and within the scope of their employment. So there's that savings to the community in terms of dollars and cents. And also, on the matter of litigation expenses, this is sort of a technical aspect, technical legal aspect, but qualified immunity is typically raised in something called a motion for summary judgment. And a party is entitled to summary judgment when the material facts relating to a particular issue are not in dispute, and then the application of the law to the facts favors the requesting parties. Usually when summary judgment is denied by the trial court, the denial is not immediately appealable, and instead those appeals would happen after a trial. However, the courts have determined that that making public officials and again, remember, qualified immunity applies not only to police, but to public officials and more broadly. But that if you had to wait till after a trial to appeal a denial of qualified immunity, then again, one of the purposes of having qualified immunity to avoid the protracted litigation, and by having to wait until after a trial.
Read the whole thing?
Yeah, just want me to close it up or?
I'm sorry.
Yeah.
Somebody else?
You guys have to put it on mute.
I was off the whole time.
No, somebody, I think it looks like somebody's still not on mute.
All right, we'll keep going. Anyway, so the permitting of these, what they call interlocutory appeals, in other words, an appeal before a trial, is one of the benefits of qualified immunity, both to police and the community, is insofar as it reduces litigation costs and that burden on taxpayers. In order to understand the importance of qualified immunity in and to law enforcement, one of the things one must understand is that law enforcement is one of the handful of professions in which the most discretion as to how to perform the work is vested at the lowest levels of the hierarchy. In other words, police work is such that police officers typically don't and can't follow a script that directs their every action in any given situation. Like every police encounter, like most human interactions, is comprised of a series of individual elements: actions, reactions, reactions to reactions, and so on. And sometimes these elements are predictable, but in many cases, at some point, somebody does something unexpected, and it would be impossible to have an advanced plan to cover every possible scenario. Now, that's not to say that police officers have complete discretion in how they perform their duties, of course. They're bound by the Constitution, by the law, and by their department policies. However, because police officers often encounter fast-moving and unique circumstances, they have to be given a certain amount of latitude in deciding how to proceed in a given case. So underlying qualified immunity is the principle that it's fundamentally unfair to hold a police officer to account for conduct that he or she would not reasonably know is prohibited. And this is why the Supreme Court determined that liability for violations of constitutional and other civil rights these are the so-called Section 1983 cases. Title 42 of the U.S. Code, Section 1983, is the law that provides a cause of action to sue over constitutional violations. The U.S. Constitution itself doesn't provide a mechanism for enforcement, and Congress did that through Section 1983. So use of force cases are particularly problematic because physical force, deadly or otherwise, is likely to be used in quickly developing situations in which some person may be at a risk of harm. So this is in contrast, say, with alleged violations concerning searches or a right to counsel, when there's a greater likelihood that there would be time for more considered action. And that's why the use of force cases tend to get the most attention. We all know that use of force by a police officer, if you didn't know, now you'll know. Use of force by a police officer violates the Fourth Amendment when it's excessive. But the term excessive is a very broad proposition, and outside of extreme cases, it doesn't really provide useful guidance. So we then have had decades of case law which developed the guidelines as to what conduct constitutes excessive force. But more importantly to this discussion is that the case law continues to evolve as circumstances arise that haven't been previously ruled on by the courts. And it's because of this continuing evolution of the guiding case law that police officers are granted qualified immunity when it is not clearly established that their use of force was excessive. And of course, qualified immunity is denied when it is clearly established. Now, critics argue that qualified immunity is given to police officers anytime there are minor differences between a particular incident and existing case law. The Supreme Court, however, has repeatedly said that qualified immunity does not require a case directly on point. However, it does require that existing precedent must have placed the statutory or constitutional question beyond debate. And what does this mean? In other words, what the court has described is that what is required is that a reasonable person would understand that the conduct in question was improper. Now, the courts find conduct to be they find the rights to be clearly established in one of three general contexts. So one is the one we've already discussed, where you have a similar fact pattern in a previously adjudicated case. But also, rights can be clearly established by showing that a broader, clearly established principle should also control these particular novel facts. And lastly, when conduct so obviously violates the Constitution, prior case law is unnecessary. And courts actually do withhold qualified immunity in cases where there are no precedents with similar fact patterns. In a case, Hope versus Peltzer in 2002, in that case, an inmate was shackled to a metal pole for a long period of time under harsh conditions. And the Supreme Court held in that case that the officers were not entitled to qualified immunity because the unconstitutional nature of that shackling in that matter was an obvious and clear violation of the Eighth Amendment's prohibition against cruel and unusual punishment. I also urge those who contemplate the elimination of qualified immunity to look carefully at the cases cited as examples of the excesses of the courts in granting qualified immunity. I've read published materials that cite, for example, a case Ramirez versus Guadarrama that was a Fifth Circuit case in 2021 as an example of the excesses of qualified immunity. As criticized, the case is described as a police response to a, I'm quoting the criticism, a call about a man having a mental health crisis, and that despite knowing that the man named Gabriel Eduardo Olivas had doused himself in gasoline and was highly flammable, one officer used his taser on Olivas, which set him and his home on fire, and Olivas later died of his injuries. Now, if this were all you knew about that case, you would understandably think it outrageous that the police were not found to have violated Olivas's rights in that case. But in its opinion, the court describes that there were other concerns involved. Olivas was himself threatening to burn himself and the home down, and there were other occupants in the home. And Olivas was holding above his head what appeared to be a lighter, suggesting to the police officers that there was an imminent danger that he was actually going to light himself afire and burn the house down. The court, in its opinion, when it granted qualified immunity, acknowledged that although the employment of the tasers led to a tragic outcome, the court is saying that it cannot suggest exactly what alternative course the defendant officers should have followed that would have led to an outcome free of potential tragedy. The court emphasized that the reasonableness of government officials' use of force must be judged from the perspective of a reasonable person on the scene and not with the benefit that the court has and we all have now with the benefit of 20/20 hindsight. The court further said that the fact that Olivas appeared to have the capability of setting himself on fire in an instant, and indeed was threatening to do so, meant that the officers had no apparent options to avoid calamity. In other words, the court found that the police in that case were faced with the impossible choice and perhaps seconds to decide. Should they take a chance that the taser would have stopped Olivas without starting a fire, or should they do nothing and watch Olivas immolate himself and set the house on fire? The other thing that's noteworthy about this particular case, which even though it's cited as a criticism of qualified immunity, the court actually found in that case qualified immunity aside, that there was no constitutional violation, and therefore it wasn't dependent on qualified immunity for its ultimate outcome in favor of the police officers. In another case, Baxter versus Bracey in the Sixth Circuit in 2018, which has also been cited as an example of the excesses of qualified immunity, in the criticism, it's described as this: qualified immunity granted for officers who sent a police dog to attack a man who had already surrendered and was sitting on the ground with his hands in the air. The court held that, again, this is the criticism, the court held that a prior case holding it unconstitutional to send a police dog after a person who surrendered by lying on the ground was not sufficiently similar to the circumstances in this case. So if you're just listening to the criticism and have not reviewed the court opinion, it sounds as if the posture of the plaintiff, right? The plaintiff in this case was sitting with his hands up, as opposed to in the prior case where he was lying down. And it sounds like that was the dispositive factor in granting qualified immunity. And that would be scorn-worthy, for sure. But in reading the opinion, there were other significant distinctions drawn by the court. Primarily, that the court in the earlier case where qualified immunity had been denied, the police dog had known issues with excessive biting and aggressive behavior, which was blamed on the police officer's failure to keep the dog on its prescribed training regimen. The court in the Baxter case, which was comparing to this earlier case, found that the dog in the Baxter case was properly trained and not overly aggressive. And ultimately, the court in Baxter reasoned that given the existing precedent in canine apprehension cases, the police officers had good reason, in fact, to believe that their conduct in deploying the dog did not violate the Fourth Amendment. So the court's decision in this case had nothing to do with the posture of the plaintiff sitting up or lying down as a fine distinction. So this seems more like it's a fair and just outcome rather than a justification for jettisoning qualified immunity. So just to be clear, I don't mean to suggest that courts never apply qualified immunity in an overly broad manner, but I do wish to underscore the need to look beyond the headlines in the qualified immunity cases. There have been efforts in some states, and as mentioned, the city of New York has already done so, to strip police of qualified immunity. And this is typically done by enacting a law which provides for a separate cause of action for civil rights violations, and then specifically barring any defense of qualified immunity to those causes of action. So, for example, the legislation that was proposed in the New York State legislature creates a cause of action very similar to that of Section 1983 in Title 42 of the U.S. Code. And the proposed law further provides, and I'm quoting the bill, it shall not be a defense or immunity that such defendant was acting in good faith, or that the defendant believed, reasonably or otherwise, that the conduct was lawful at the time such conduct was committed. Now, more importantly, the law further reads, nor shall it be a defense or immunity that the rights, privileges, or immunities were not clearly established at the time of their deprivation, or that the state of the law was otherwise such that the defendant could not reasonably have been expected to know whether the conduct was lawful. Now, I know that was a lot to digest, but let me highlight this. What the proposed law says, a defendant, in this case a police officer, who could not be reasonably expected to have known that his conduct was unlawful, will nevertheless be held liable for his conduct. And we're not even talking about a defense that a police officer who reasonably believed the conduct was proper. The proposed law would purposefully hold police officers to account for conduct which the statute acknowledges that the police officer could not know was unlawful. So again, it's important to look at the context in which these claims arise against police officers. Not every not every alleged violation of rights involves a use of force, and sometimes these cases result from non-emergent situations. But in many of these cases, police officers are involved in rapidly developing situations in which the police officer may need to make decisions in seconds or even fractions of seconds to act against a threat against the life or safety of members of the community or of themselves. It's difficult enough to measure these circumstances as they're evolving against a body of existing law governing acceptable police conduct. But the proponents of this legislation believe that police officers should also measure rapidly evolving dangerous situations against standards which have not yet been clearly established. So understandably, when a person is injured or worse by a police officer, there's a demand for recompense. That's understandable. But not every injury is the result of culpable conduct. And the question is the community actually better off when police officers are held responsible for violating a standard that had not yet been established? In the criminal context, this would be an unconstitutional ex post facto law. Section 1983 claims, however, are civil rather than criminal in nature, but as a matter of fundamental fairness, it seems that the principle ought to apply. So, in summary, the benefits of qualified immunity are fairness to the extent that police officers will be found responsible only for civil rights violations when they could have reasonably known that the conduct would constitute a violation of civil rights. Second, that communities will not suffer from overly timid policing. Third, litigation costs are curtailed through the permitting of interlocutory appeals. And fourth, communities are not compelled to pay damages for violations of rights that had not been previously clearly established. In closing, I'll say this: judges are human beings, and they are therefore fallible. Qualified immunity may sometimes be read too broadly, resulting in injustice to an injured party. But I don't think the answer lies in throwing out the proverbial baby with the proverbial bathwater. Rather, a solution. I'm sorry? Rather
Donnie, you, I'm sorry.
The solution should lie in either establishing legislative.
I'm sorry, Dr. Weiss. Captain Donahue, can you mute, please? Thank you. Okay.
Apologies.
Right,
baby, bathwater. I posit that the solution should lie in establishing either by establishing legislative parameters as guardrails for the courts, or crafting these alternative state or local causes of action, which more strictly define the permitted defenses along the lines of qualified immunity, instead of eliminating them or subverting the doctrine entirely. So I thank you for your time, and Katarina, it's all you.
Thank you so much. Katarina, I'll let you go. I just want the record to show that was a fellow police officer that interrupted you and broke up your flow there. So I just wanted the record to show that. Okay.
Well, let me throw out the record show also that would be typical.
All right. Thank you. Katarina, please give us the benefits of this for the community.
Sure. Thank you again to the PRAC and to the mayor and for everyone for being here. I am not a lawyer, though I feel like I'm cosplaying one sometimes being in these conversations. And so I did make a presentation. I do thank Dr. Pope for explaining what is often a really complicated topic or idea pretty eloquently. So you kind of made my job a little bit easier than it usually is. But want to give you an overview. You can go to the next slide, Pastor. From the perspective of more than 70 plus organizations and hundreds and hundreds of individuals across New York State who are fighting to reform qualified immunity, and we're fighting specifically to pass the bill S-176 and A-1402 in the New York State legislature. And, just want to also highlight that I think all of us are ultimately coming at this, for the same reason. We all want everyone to be safe. We want everyone in New York State to be safe. As you heard in my introduction, my background is in peace building. It's what I study, it's what I teach, and that's very much the approach with which I come to this conversation. And I appreciate the ability for us to all have a nuanced conversation rather than kind of, sort of be stuck on one of the extremes of what has been dubbed a controversial topic. But actually, if we looked at what this bill would do, and hopefully I'll have time at the end, we would see that this is actually a very fair and balanced approach to reforming qualified immunity. Go to next slide. So we'll skip this since Dr. Pope already covered this, but just a reminder, this is a Supreme Court invented doctrine. It's not law. So that's just something that I really want us to highlight. And so I'm going to go over a bunch of reasons why for the community would be beneficial for us to reform qualified immunity. First, protection of our rights. Second, justice for those who have been harmed by public officials, accountability and public safety, and building kind of that case law that Captain Weiss was referring to. Next slide. So I think first and foremost, let's contextualize where we are in this exact moment. And this has been something that we've been building to for several years. But it is clear that on many different fronts, the federal courts are rolling back the rights of Americans. And so it is extremely important that given that we don't have a civil pathway in the state courts, and because we are blocked by qualified immunity in the federal courts, that we do reform our access to accountability and justice here in New York State. And this is not something, this is something that really can impact all of us. So we really are interested in making sure that at the New York State level, we have safeguards here in New York State, given all the shenanigans that are happening in the federal courts, to protect our civil rights. And let's let these cases play out in the courts. Next slide. So first and foremost, I think what we center in our campaign, and we've been really fortunate to build with so many people who have been harmed by public officials, who have lost loved ones at the hands of police officers or correctional officers, is that those who have been harmed, both their families and those who survive that harm, deserve a chance at justice and accountability, right? The way that it plays out right now in practice, this is not a theoretical conversation, means that often these cases are dragged out as qualified immunity is kind of litigated, and it adds on years and years to cases. And so I'm sure many of you, in Westchester know the horrific story of Kenneth Chamberlain Sr., but Kenneth Chamberlain Jr. was in the courts for 14 years, in large part due to qualified immunity bouncing the case back and forth through the courts. And when you hear advocates say justice delayed is justice denied, that's not just some slogan. That has actual meaning to it, right? Imagine I can barely remember what I had for lunch yesterday. Imagine 14 years later, if you're back in the courts, who is going to really remember what exactly happened in the moment in question. People move, people pass away. And so this really does impair the ability for those who have been harmed to get justice when it causes these extreme, this extreme dragging out of cases. And having worked directly with families, it is agonizing for them. I think the other thing that we hear families say often, who have actually come up against qualified immunity in New York State courts, federal courts in New York State, is that they just want their cases to be heard and decided on the merits. So as Dr. Pope alluded to, qualified immunity in practice has evolved over the years. And so while there used to be a two-prong, question there, cases now no longer have to be, courts don't have to decide whether a constitutional violation has happened if they deem that this same exact thing hasn't happened in the same jurisdiction. And so, we were talking about case law and evolving case law. This is bad for all of us because this actually stunts the evolution of case law, right? So one, it's bad for families. They don't get to have the courts hear and decide a case on the merits and the facts because they are thrown out because of qualified immunity. Two, it's bad for all of us because that case law doesn't evolve. And as Captain Weiss alluded to, that would be bad for law enforcement to not have that evolving case law so that it's clear what is within the parameters of acceptable action. And another thing that I wanted to mention as we, within this topic of justice for those who have been harmed, and that has been alluded to, is somebody pays the cost of all of this, right? There's a lot of conversation about who that should be. But right now, I just want to highlight that without doing any qualified immunity reform, that we are deciding that victims should be the one to bear the cost. And again, these aren't abstract ideas, right? whether it's flying up to Buffalo with a private detective to get statements from, other incarcerated individuals, whether it's going through therapy, whether it's, all kinds of actual costs that we are saying we want the victims to bear unless we reform qualified immunity. And so I really want us to keep those people who are harmed, at the center of this conversation, because they are the ones who have suffered, and then they are the ones who we are then requiring to bear the cost. You can go to the next slide. For those of you who don't know the Kenneth Chamberlain story, I just wanted to uplift that Kenneth Chamberlain Sr. was a 68-year-old Marine veteran, lived in White Plains. He had a heart condition, and so he slept with a life alert necklace on, and he accidentally set that life alert alarm off at 5 in the morning. Life Alert calls, and the reason why we know all of this is it was all recorded by Life Alert. Life Alert called the police. The police come to his door. He says, "Go away. I don't need any help. I'm fine. Please go away." And then over a few hours, that the situation escalated. Police officers eventually break down the door, tased him, shot him with beanbags, and eventually fatally shot him in the chest. And then Kenneth Chamberlain Jr. his son was left to pick up the pieces and fight for originally justice. But after 14 years, he will not call it justice any longer, but fight for some accountability. I hope that you all get to either watch the movie, The Killing of Kenneth Chamberlain Sr., or hear Kenneth Chamberlain Jr. Speak on this, because I think there's no better advocate and person to explain, what are the real impacts of qualified immunity, and again, why we need to change it. Next slide. So again, we really have always centered public safety in this conversation. And again, this is part of my professional background, so absolutely paramount to, our approach to this. What qualified immunity, whether it's real or not, causes the perception of, some get to be above the law, right? And if we want to have true public safety, no one should be above the law. And we've been really lucky to work with law enforcement, various law enforcement agencies and organizations and individuals, throughout these 5 years that we've been working on moving this bill forward. So we've had the benefit of having the support from the Law Enforcement Action Partnership, which is a national organization of police, sheriffs, prosecutors, et cetera, who in their letter of support of this bill really highlighted the impact that not reforming qualified immunity. So the impact of qualified immunity has on communities and the relationship between communities and law enforcement, is really negatively impacting our ability to ensure public safety, because it harms trust, right? And so if there is harmed trust between communities, and, I appreciate Dr. Pope particularly centering communities of color, other marginalized communities, where, there is a long history and legacies and reasons for distrust. We are not helping that if we are kind of signaling that there is often no accountability when these harms happen. We've been also really lucky to have the support of Everytown for Gun Safety and Moms Demand Action, who again really want to move this legislation forward so that we can, repair trust, enhance trust between law enforcement and communities, so that we can prevent gun violence on their specific case, and more broadly, just support public safety in New York. And so, again, we've been really lucky to have the support not just of these organizations, but the police chief of Albany, the deputy police chief of Rochester, and many other law enforcement officials who understand that this is critical to really enhancing public safety more broadly. Next slide. So, I do appreciate also Captain Weiss, making it clear this does not just apply to law enforcement, and actually our campaign does quite a lot to kind of just broaden this conversation. We are not anti-law enforcement in any way, and so this is something that all public officials benefit from when they are acting within their public duties. But it's easy to sort of think, immediately in our conversations, we've heard this time and again, well, I'm someone who follows the law. What does this have to do with me? But the reality is that any of us can be impacted by qualified immunity and not reforming it. And sometimes this appears, in surprising places. So this is not only in those split second decisions, which does have those split second decisions have other constitutional protections and for law enforcement. But for example, at work, this is a real case from New York State, from Buffalo, in about a gentleman who worked at the Erie County Water Authority, and his supervisors started to discriminate against him. He was a white man married to a black woman, started to discriminate against him for being in an interracial marriage, eventually terminated his employment. And the courts decided that there was no clearly established law to protection against that kind of racial discrimination. And the public officials at the Erie County Water Authority were granted qualified immunity, right? Can happen at school. We hear all kinds of concerns from parents and students from, middle school to universities. And this is, again, a real case where a 13-year-old was strip searched by school public resource officers because they were concerned and looking for Advil, or Tylenol. So, these are real harms. That case went all the way up to the Supreme Court, and the public officials were granted qualified immunity because it wasn't clearly established law that it's inappropriate to strip search a 13-year-old in search of Advil. So these are just some of the ways that this can really impact any and all of us. Also, just want to highlight, particularly as concerns around mental health are rising here in New York State and across the country, that those who are suffering from mental health have exponentially higher rates of being having fatal encounters with public officials and with law enforcement. And so again, you never know when you might come up against this. I started this campaign with Darlene McDay, whose son was killed by corrections officers, and she always so poignantly and just heartbreakingly points out that she never thought she would be in this position where she would be fighting now 5 years later still to get some sort of accountability on behalf of her son, who was brutally beaten by corrections officers. So just want to kind of make sure that, we all know that none of us are immune from this, and that all of us would benefit from reforming qualified immunity. Next slide. So I also just want to highlight that while this is often, deemed a controversial issue, that there is great support for this across the state. This was polling done by YouGov, where we found that 69% of Democratic voters said that they wanted their public officials to end qualified immunity. 48% of independent voters supported ending qualified immunity, including many Republicans. So this has bipartisan support. We also have support of several conservative organizations. So this isn't that kind of partisan issue that is sort of imposed upon us, but really an issue about accountability, fairness, justice, and public safety. So with that, I know I've taken up quite a bit of time, but I'd also love the opportunity to just briefly go through the bill that we are advocating for. If maybe, Pastor Mary, if you could go to the last slide, because I think it does really touch on some of the, next slide. Yeah, on some of the concerns that Captain Weiss raised, but really this bill that we're advocating for is quite a fair and balanced approach. And it does, for example, really balance individual and systemic accountability, right? So it ensures that all public officials can individually be sued for civil rights violations, but the public entity is the one that would be financially responsible. And we think that that's a really elegant balance of making sure that victims actually do get compensated as the courts decide, not bankrupting any public official. That's not what we want to see. And this bill would ensure that, that wouldn't happen. It codifies indemnification. And it also does quite a bunch of things to incentivize systemic change, which is another reason why law enforcement officials such as Chief Cox have supported this bill. No one wants to punish. This isn't coming from a punitive perspective. This is really coming from a desire to create some systemic change where it needs to happen. And so there's all kinds of pieces of this law that, really encourage that systemic change, even, in cases where officers are, not found liable. So happy to share more about the bill and look forward to the questions and the conversation. I see there's a question, who are the sponsors of the bill? So in the House, it's Assembly Member Pam Hunter from Syracuse, and in the Senate, Robert Jackson from New York City. And we've been really lucky to have their support. This has been one of their priority bills, if not their priority bill, for the last 5 years. And we have, over 23 co-sponsors. So that's more than half of the Democratic caucus, for example, in the Senate that supports the bill. And we have 43, I believe, assembly members who have co-sponsored the bill. There are others who support it who have not yet co-sponsored the bill. But
Okay, baby.
we're looking forward to kind of continuing to build with you all and Ossining, and hopefully following, the lead of Rochester, for example, whose city council just passed a resolution in support of this legislation.
Okay. Thank you all three of the panelists for sharing this detailed information from all of your perspectives. I have a couple questions, and then I guess we can open it up. So one of my questions, I work in IT, and it's one of the things we always say is that in theory and practice are the same, and in practice they rarely are. And so we have 4 states that eliminated qualified immunity. So is there any evidence, any data that shows any increase in cases against police officers, any situations where in those states, I believe it's Colorado, New Mexico, can't remember all the states, I had them written down, Montana and Nevada are the states that have in qualified immunity. Do we have any data that shows any change in the laws, cases against police officers, lawsuits, anything like that against police departments?
So I can speak to Colorado. Sorry, Captain Weiss, you can go after. Where we
No,
were.
go ahead. I really can't speak to Colorado, so that's fine.
Okay. Where they eliminated qualified immunity only for police officers. And we don't have the exact figures, but we have spoken to many prominent civil rights attorneys, and it's a small community, including the civil rights attorney for Elijah McClain's family. And she said it was very clear that following the elimination of qualified immunity, they did not see an uptick in cases. So there was no flood of lawsuits. And actually, the lawsuits had gone down because misconduct had gone down. And so, that's part of the theory of change, right? That with the knowledge that you will be accountable, not bankrupt, not put out on the street, but, have to go through the courts and have the case decided on the facts and the merits, you can make different decisions.
I was just going to suggest, Katerina, I'm trying to trill that R.
Don't worry about it.
When was the Colorado law changed?
In 2021, I believe.
Yeah, I mean, I'm going to suggest, because I tried to do some research and I couldn't find anything really consequential. I would suggest that police conduct didn't radically change in that period of time, because that's really going to be a result of finding out outcomes and training. I think the likelihood is that it's too soon to really know what the impact is going to be of these things, because some of these cases are going to have to make their way through the appellate courts. And one of the things I actually noticed was New York City. It looks like the few cases I found that were filed under the New York City law did actually go to federal courts. So the interesting thing there is going to be to see if the federal courts are going to how they're going to deal with that. Because even though for a statute that says that that even if you couldn't know what you did violated the law, I don't know how they're going to deal with that. We haven't seen the appellate cases yet, so it's probably a little early to know what the impact of those laws was going to be.
Sure. I can't fully speak to the impact on policing, but the question, on what sort of impact it had on cases being brought forward, we saw that there was a reduction in cases.
And that reduction was probably spurred on during that 2019, 2020 and 2021, 2022, you have COVID. So, we have to look at the impact of COVID on policing during that time, and things that came about during then. So, that was an unprecedented time, and it showed unprecedented challenges. So, of course the numbers are going to be down when it comes to police conduct, because, people were inside. All right. So, there you go with on that point. And that's where you see the lack of data, specific data. So
Right. I'll ask one more question because it's just pertained to something that Katarina brought up, and I think is relative to some of the stuff that's going on now in politics. And one specifically, you mentioned the student being searched, strip searched. The House passed the bill, and I know it may not get passed any further, this trans sports bill, which is looking to allow schools to search children who want to play sports to check their genitalia. And so, like, this qualified immunity question that overlaps this weird space with laws being passed at the federal level. Like, is this something that would have to go to the Supreme Court? Like, does this fall within that realm? Like, how would this affect something like that for school administrators that are abiding by this new federal law that can potentially be passed?
I don't have a great answer for that, but what I can say is that, more broadly, given some of, that context that you're alluding to, Mr. Smith, we want to shore up our rights here in New York State. And I think we're doing that on many fronts. But when it comes to our civil rights, it's really important that we are shoring that up. And that we have the ability to choose to go through state court. It doesn't require you to go through state court. You could still choose to go to federal court if you wanted to. But that we have the ability to kind of let these kinds of cases play out, and give New Yorkers a pathway to do that here in New York State right now.
Okay, great. And I don't know if Dr. Pope or Captain Wise, you want to even dive into that. If not, then I'll give, what I want to do is give my fellow members of PRAC as well as the CPCRB an opportunity to ask any questions they may have. And if not, then I can jump into a couple other questions that I have. So does anyone have any questions that they would like to ask? Please unmute and you can ask your questions now.
Yes, I have a question. This is Bishop Joan Whitaker. Can you hear me?
Yes, go ahead.
Thank you, all the panelists. Dr. Pope, in your experience working with the NYPD and your other experiences, can you share with us your observations in terms of the benefits to the community that you have observed through qualified immunity?
unmute. The benefits to qualified immunity?
Yes, sir. Based on your experience.
Based on my experience,
Mm-hmm.
it's basically holding people accountable, and it's holding everyone accountable. I always go by there's a couple of things that we say and we say every day in the police academy, and it's a couple of things I truly remember from that, and it's in partnership with the community we pledge to, and one thing is to maintain a higher standard, you know, than others because so much is expected of us. So that being said, police, and especially policing in communities in New York City, they have to be able to have a certain level of emotional intelligence, in order to be able to, basically work with each other. And that goes on both ends. Both are accountable.
Okay, thank you, sir. And Jermaine, if I can I just do one more question real quick?
Sure, you one more, and then we get Jennifer.
Okay, all right. So I am learning, and this is a doctrine, and it's not a law. How is the process carried out? Say, for instance, if something happens in Ossining, and there's an incident between a police officer in Ossining and an individual. How does it go through the court system? Does it go to the state level automatically, or the federal level, or how does it work in a practical way? That I'm not quite clear on.
Well, it depends on the nature of the incident. Now, first of all, there's all different directions something could take. So, for example, first of all, you've got the distinction between whether criminal charges are brought against a police officer for inaction versus a civil suit. And if you're talking about criminal, there are also state tracks and federal tracks. Plenty of police officers have been indicted for bad actions in both the state courts and by the federal courts. The U.S. Attorney's Office has taken that on. The District Attorney's Office have taken those cases on. So when the police conduct rises to the level of criminal liability, they're prosecuted criminally, like I said, neither the state or federal courts. And then you have the civil suits, that's most of what we've been talking about this evening, the actions that are brought under Section 1983. And those are typically brought in the federal courts. But those are choices made by the plaintiffs, the people making the claims. Ostensibly, if there's a state cause of action, you could bring that in the state court, or you might. I think the likelihood is, and I don't know, Katerina can tell me if it's different, if the experience is different in Colorado. But I would imagine that most litigants in these cases would want to avail themselves of both the state claims and the federal claims, which would take them into federal court typically, because the state courts won't adjudicate the federal claims, but the federal courts can consider the state claims when they're brought together with federal claims.
Okay, thank you.
So I just would love to add that, me, the person, us, the people of Ossining, we don't have actually any say in whether criminal charges are brought against a public official. That's up to the AG or the U.S. attorneys to decide that. And that happens very, very rarely. We also don't have any say in what happens, in terms of any sort of employment consequences. Those kinds of decisions are mostly decided through union contract negotiations and the various arbitration processes that different unions across the state negotiate. And so what the regular people are left with is this pathway in the civil courts, as Captain Weiss mentioned. But right now, more or less, the only way you can bring a civil suit, a civil suit for civil rights violations against a public official is through a 1983 action, which has to go through the federal courts. And so this bill instead would create a new pathway in the state courts to bring those cases. Dr. Pope, you're the lawyer, so jump in if we're getting any of that wrong.
Thank you for additional explanation, Katerina. Jennifer, you had your question.
Yes. Can you talk about what other municipalities have made resolutions in support of this bill or are considering it?
Yeah,
I guess
so
that's Loretta.
we're really thrilled that just under a month ago, the Rochester City Council passed a resolution, and that was a particularly poignant one because it also mentioned Robert Brooks in the resolution. I don't know if you're all familiar with the case of Robert Brooks. He was someone who was incarcerated, in upstate New York, and was fatally beaten by correctional officers. And that happened to be caught on camera. And so it is one of the rare circumstances where criminal charges have been brought. He's from the Rochester area. And so it was really powerful that the Rochester City Council decided to take that on and support this legislation in his, partially in his honor, but also for the well-being of all Rochester residents. We have, a resolution that has been introduced in New York City Council, where, as Dr. Pope mentioned, they have, limited qualified immunity for police officers. But yeah, that was introduced by Yusuf Salam, who I'm sure most of you know, one of the Central Park Five, and we're really grateful for his support and collaboration on this effort as well. And then we're working, on a few different smaller villages, equally important villages and towns across New York State, but I don't want to get ahead of, what the fine people of all of those towns and villages are doing. But stay tuned to kind of hear, as we continue to, build this momentum.
Thank you. Jermaine, there's a question in the chat. I don't know if you saw.
No, I did not. The village board and the Austin Police Department makes those decisions. Kimberly, is that regarding the criminal cases? Do I see, is Kimberly still on? That's regarding criminal. What the decision on when to charge an officer with criminal charges?
Correct.
Okay. I don't know if one of you want to answer that. So Kimberly was asking, does the village board and the Austin Police Department make those decisions on when charges are filed against police officers? And I think you kind of answered that, Katarina. You can just explain that again.
Sorry, could you repeat?
Kimberly, she's asking whether or not the village board or the Austin Police Department makes the decision when criminal charges are being filed.
More so disciplinary charges. When we review a case, per se with the CPRCD, we go through the chief of police or the OPD and the village of trustees. They make the decision. We determine, well, we all vote on if it's substantiated, whatnot, and then it's up to OPD and the village board trustees to decide the disciplinary actions of that police officer. So my question, go ahead.
Finish your question, Kim. Sorry.
Well, that's it. Zimmerman and I have worked together before, so I will allow. Go ahead, Zimmerman, please.
Thanks. I think we're kind of conflating the two issues here. Anything that would go to the CPCRB is thankfully a far cry from anything that would end up in the realm of whether or not something is eligible for qualified immunity or not. So, but if there's a criminal charge,
on the matter of criminal charges, I can say this: that first of all, the decision for a police agency to refer something to the district attorney's office for criminal charges is going to be made by whatever the authority of that police agency is. So I imagine, Chief, with respect to listening, that would be your office in connection, perhaps with your board of trustees as your police commissioners. Here in the County Department of Public Safety, we have had occasion to refer matters to the district attorney's office, and that's done under the authority of the Commissioner of Public Safety. But just with respect to the connection between the administrative and the criminal action, right? So the likelihood is that someone who has done something that would be criminal would also be subject to administrative action by the department. Typically, in those cases, the criminal case is going to be proceeding first, and that's because there are certain Fifth Amendment issues raised in investigating matters for administrative purposes, and as a result of that, in most cases, the criminal case is going to proceed before any administrative case goes forward.
But you do know that civilians can file criminal complaints directly against, to the DA's office. And that being said, the DA's office does have mechanisms within their structure to investigate those cases as well. And you have, various DAs. You have Westchester County, New York, Bronx, Queens, Richmond, Kings, and so on and so forth, and other counties.
And if I could add, the New York State Attorney General's office also takes complaints online through their it's a whole bunch of letters. The Law Enforcement Misconduct Investigative Office, and you can go online to the AG's website, and if you want to make a complaint there, they'll and if it's criminal, they'll investigate it or refer it.
Thank you. Leah, you have a question.
Just to be super clear, qualified immunity is only in civil lawsuits. So just to not confuse that's something that confuses people often. Yes. I just want to make sure that's clear.
Leah.
Thank you all for this great panel. It's one of my pet subjects. And my name is Leah Nelson. I'm a member of Westchester Coalition for Police Reform. I just have some comments or questions for Captain Weiss about some of the comments you made in support of qualified immunity, because sure. I mean, I've talked to a lot of civil rights lawyers, and one of the things saying that there would be protracted litigations if police didn't have this qualified immunity. What I have been told is that the courts decide what are frivolous lawsuits, and they certainly wouldn't allow frivolous lawsuits to be
right. I didn't say
litigated.
Frivolous. Right, but frivolous and protracted are two different things. Protracted is that they take a long time. Frivolous, I'm not suggesting that frivolous claims get through without qualified immunity. Again, I would point out what I am most concerned about in the absence of qualified immunity is, and again, these things are all issues that are subject to interpretations by various judges, which is why sometimes it's read more broadly than not. But I am concerned by things like in the proposed legislation pending in the state legislature now, where they would eliminate a defense even when it's acknowledged that the police officer could not know that his conduct was wrong. And
however, there are still other protections, especially for police officers, like the Fourth Amendment determination whether a police officer's actions were excessive or not.
I don't see how that's a protection.
Of course it is a protection. The courts use that to determine whether or not the case is valid or not.
Well, first of all, the Fourth Amendment doesn't use the word excessive. The Fourth Amendment uses the term reasonable. But the real question there is. So
let me just finish. Sure. They have that protection, and they also have the union protection.
I'll let you finish this one question. I did forget that we were only taking questions from the Police Advisory Board and CPCRB, but I will let you finish this question, and then
okay.
I was just going to raise hand. I apologize for that. That was on me.
I'll shut up.
Just finish this one question, okay? So I do apologize for when I was just going to the raise hands, but we were only going to take questions from the Police Reform Advisory Committee and the CPCRB. So do we have any more questions from anyone on any of those two boards? Okay. I just have two general questions. I know we're coming down to the end of time. We're coming within a couple minutes, and I want to give you guys opportunity to have any closeout statements that you have, our panelists there. But two questions. One, to my understanding, there's ways where an officer negates their qualified immunity. Can we just share that with the public as far as how you can negate your qualified immunity? And also, a second part or a second question entirety does qualified immunity have to be applied by the officer within a certain time, or is it just blankly applied after a case? So can it be waived if they don't apply it in a certain amount of time, or if they don't apply with sufficient evidence or information about what's going on in that situation?
Second question is the easier one, so I'm going to answer that one. And the answer to your second question is that it's actually something I referenced in my presentation, is that qualified immunity is a defense that's typically raised in a motion for summary judgment. So the timing to bring that really depends on the court rules with respect to the making of motions, but they're typically done early in the case. It's probably also pled as a defense in the answer to the complaint. So that happens early on. And that's actually what the courts, one of the purposes of the doctrine, as the courts laid out, is that it should occur early on, so that if it is dispositive of the case, it's addressed up front.
Right. So I was asking that specifically because I want to make sure that it's clear to the public that it's not blankly applied automatically, that they have to apply that as a part of their defense. So I just want to make that piece of it clear. Okay. And then the second part is whether or not there's a situation where it can be negated, as a situation where there's a false imprisonment, for like if they were arrested without probable cause or anything like that. Does that automatically negate qualified immunity?
Okay, I guess I'm going to try that one too.
I'm not a lawyer. I don't know.
So that wouldn't be automatically negated, but like I said, there are cases where the courts have said that there are some violations of rights which are so obvious that you don't need prior similar case law. But the way the litigation process works is that a claimant or a plaintiff is going to file the lawsuit, and it's going to lay out all of their claims. Defendant is going to spell out his answer, which is going to include in a defense of qualified immunity. At some point there will be this summary judgment motion. To the extent that you're talking about negating, I mean, that'll happen based upon the facts, right? If it's the case that the police officer's conduct is so outrageous, as in the case I mentioned about the chaining a prisoner to a post, where the court says, listen, you don't need similar case law to know that that's wrong. But it's it's just denied in that case. It's not negated. It's denied because the facts don't support it.
Gotcha. All right. And that was just a broader question about that. And so thank you for that explanation on that. And do we have any questions, any follow-up questions, anything like that from any of our two board members?
I'd love to also, while the hands are raised, just offer to share a little bit of follow-up from some law professors that we work with on kind of the additional protections. So, there are other procedural and substantive protections that are found in the Constitution for both reasonable mistakes and split-second decisions. And so I just want to offer to send that over to the PRAC just so you can have a look at that and consider that, given that I don't have that exact information right now.
That'd be great. Thank you so much for that. All right. So I know we're coming out. We have about 5-6 minutes left before our 9 o'clock hour. Jennifer, you have another question before we close out?
Oh, I did actually. For Dr. Pope. If we were in a situation where qualified immunity had been eliminated, what would happen in a civil case in the absence of qualified immunity?
In the absence of qualified immunity, what would happen in a civil case? I think that would go on, basically because it's a balancing act. So while qualified immunity aims to, protect officers from lawsuits, it is important that, we look at this, we balance this out to where victims, can have some timely justice. But, but to address these questions, it's it depends on the incident itself, just to be
Right.
fair. It depends on the severity of the incident itself,
So would the case just proceed as normal? That's really what I'm asking.
You would on that point, it depends on who's bringing the case forward and whether there's ample enough pressure to, go ahead with it and proceed. If that answers your question.
Yeah, I think what I'm getting at
is that in some jurisdictions you'll have you'll have officials that will be that would go forward and press that incidents, and in other jurisdictions you may not. Bronx County is different from New York County. New York County is different from Queens County. Queens County is different from Richmond County. Richmond County is different from Kings County. Kings County is different from Westchester County. So it depends on who's at play and who's at sway. And I think Captain Weiss had mentioned that earlier before. You put the pressure on our judges. They are elected officials. And you can have one that can go either to the left or either to the right, or just plain simple down the law and go moderate and go up the middle.
Can I if I could approach that answer from a different angle? What would in the absence of qualified immunity? Don't forget, again, qualified immunity is a defense. And I say, hey, judge, this claim has been brought against me, and my defense is that this was a novel case, and I had no way of knowing that my actions would be deemed by the court to be improper, right? So if I'm not permitted to raise that defense, what happens is the case proceeds, and if it's found to be that I violated someone's rights, then there's going to be a big old judgment against me because I wasn't able to raise that defense that, hey, I had no way of knowing that was wrong.
But are there other defenses that you would be able to?
In this case, in this civil case, that would be based upon the preponderance of evidence.
But yes, there are other defenses that are found in the Constitution that do protect. Yeah, there absolutely are, and just not knowing. I understand the sensitivities of this, but I think what we're trying to say is we want to equal the playing field between communities and public officials. Not knowing is not a defense for the average person.
But this is not. Before we continue with this back and forth, we can't continue with the back and forth. Let me get one last question from Michael. But I do agree with Katarina from the perspective of we seem to be holding civilians to a higher standard of police officers, where ignorance of the law is not a defense for us, but it seems to be a defense within qualified immunity. So there's some murkiness with that from my perspective. I'll speak for me personally, but let's get the question from Michael, and then we'll allow you guys an opportunity to close out some comments.
Thanks, Jermaine. More of an understanding / question. So just to put this in perspective, currently somebody feels violated, they can sue the police department in the current municipality and not the officer, correct? Without qualified immunity, if that was to go away, then they could also add in going after the police officer themselves, correct?
You go after the police officer now.
Yeah.
Now, even with qualified immunity, the police officer is subject to suit.
Right. So they still are, right?
Right. What qualified immunity says is that, and I'm sorry, just to address this point, when we talk about ignorance of the law, this isn't a police officer who says, gee, I didn't know the Fourth Amendment prohibited the use of unreasonable force. This is the case where a court determines, maybe for the first time, that the use of particular force in a particular instance is improper, right? So that's not the case that the law was out there and I didn't know what it was, right? That's the ignorance of the law is no defense. This is the law hadn't been developed to say that this was wrong, but after I do the thing, a court for the first time says, hey, by the way, that thing is wrong. So
And
it's a little different.
I'd love to
but I
just
do
add,
think, I think the
Joanna,
salaries are
Whether they were acting.
Joanna Schwartz has done a lot of work on this, and definitely recommend you all looking into her work. But she has found and really deep studies that again, there's a little bit of a question around that argument because often there is no practice, and please correct me if I'm wrong. I would love to know of following court decisions and then incorporating every single new court decision and case law that's developed into police training, on a daily basis. And so again, there are other standards that will protect for those split-second decisions, but to say that just because this exact thing hasn't happened in this exact jurisdiction, so let's say it was found unconstitutional in Texas, that won't matter here in our jurisdiction. And so I just want to highlight that as well.
So we're at the 9 o'clock hour, a little bit after 9. So I'll let our panelists close out with any final comments or things they want to share. Like again, I think this is an in-depth conversation that will be going on for a long time, having these conversations about. And so I do disagree with some of the points, but let's, for the sake of time and get everyone back to their families, let's go out and allow the panelists to close out. So I will let Katerina, if you want to close out, to start with you, and then we'll go across the board with our panelists here.
Sure. Again, I really, really appreciate the opportunity to have these frank and difficult conversations. And so I'm very grateful to Captain Weiss and to Dr. Pope for, having what is often a difficult conversation. If you have been moved by, some of the things that I've shared about the impact on community and would like to get involved, please reach out to us at team@NQINY. I'll put it in the chat. And, maybe Pastor Mary, if you're able to share our slides, which also has our email address and ways to get involved. We'll be going to Albany on April 29th for an advocacy day for this bill. And, it is always a really powerful time when we come together in Albany. And so welcome any of you who are interested in joining us. Thank you again.
Thank you so much. Thank you so much. Captain Weiss?
Thank you also to everyone who participated. This is actually a first for me, so I'm glad you all made it a pleasant enough experience. I've been involved in internal affairs for about 10 years and training for about 3 here at the Westchester County Police Academy. So I am heavily invested in both police accountability and training to avoid those situations for which police officers will eventually have to be held accountable. So I've already expressed some of my concerns, but I do recognize that there is a need to ensure that police officers are accountable for actions that they wrongfully take. One of the things that I would also urge is that while we're also looking at the legislative and litigation side of things, is that police training is especially important in this, and it's one of the things that we never do have enough of, and unfortunately, it's typically the first thing that is set aside because we don't have the money for this, that, or the other, and it's often training that gets the short shrift, and better training, in addition, better supervision of police officers will help alleviate some of these situations as well. So I thank you all for your time and consideration.
Thank you so much. And Dr. Pope?
Okay, I'd like to thank you all for the attention and the opportunity to contribute to this important conversation. But on one fair statement on qualified immunity, of course, like we said, it is a legal doctrine designed to protect police officers from civil liability. But that being said, when they do perform their general duties, especially in good faith, but ensuring that they can make quick decisions in high-pressured situations without the fear of personal lawsuits, basically doing their job, all right? However, on the other flip side, it raises concerns about accountability, in which Captain Weiss did mention, all right? And also it can be preventive, when it comes to victims, with police misconduct and seeking justice, for civil rights, human rights, especially when they are denied. So I thank you and good night.
All right, I would like to thank our panelists for joining tonight. I would like to thank all the board members, not only from the town, but from village, but also from the town, the police officers from the Austin Police Department, and of course our board members from PRAC, as well as the CPCRB. Normally, as a moderator and a host of a panel like this, you get the last word and get to put things out there without having people come back. I would not like to do that. What I would like to do is engage with conversation at a later time with Dr. Pope, Captain Wise, and Katarina with some follow-up questions. And I would invite everyone on the call tonight to do the same. If you have any questions that you have or that you think of after this, if you do not have their email addresses, you can email us directly. I think everyone probably has my email address on this call. If not, you can reach out. I'll share it in the chat. Or if Pastor Pfeiffer, if you can share our email address for the community at large, we will be in contact with the panelists with any follow-up questions that you guys do have. But again, we would love to thank you guys for the opportunity to share that information with us tonight, and thank you all for attending.
Thank you.
Thank you very much.
Thank you.
Thank you very much.
Night.
Thank you.
Thank you.
Be safe, everyone.
My email is in the chat.
Good night, all.
Good night.
Good night, everybody. Thank you.
Night.
Right.
Night all. Good job.
All right.